or fifthly, whatever it is taken, doesn't by inducement, including giving or receiving of payment, benefit that not something in order to achieve the consent of person. No, 6.3 will apply where, my lord, I am undertaking, my lord, the person, taking the person for the purpose of recruitment, transportation, harboring, transferring, or receive. 6.3 will apply only, my lords, in the context of the A to E. But anyway, my lord, this, according to me, it's clear. It is not made out as far as 370 is concerned. Now I straight away come to, my lord, my submissions on 370. If your lord, Lord, there is one other judgment on, my lord's recent judgment of Honorable Justice Suryakant on this harboring, on this 370. It was a very interesting case. Kidnapping. One of the ingredients was kidnapping, and allegation was, my lord, there was a maid. She was, my lord, she made a complaint that certain persons trafficked her, got her to her employer, and the employer, she was with the employer. Then she says to the employer that I am not willing to work. I need to go back. Employer, my lords, kindly note this. He locks her inside the room, but gives her a mobile. So you can contact. And you can go when I find a suitable alternative. He was roped in for trafficking. Although one of the facts was that the girl did say that I have nothing in particular against my employer, but 370 just can't go by consent or a compound rule. So, my lord, the court went into the question as to whether 370 is made out. And then, my lords, in that context, please have a look at Ajay Malik, that's in the compilation 2025, SCC Online, SC 185. The facts, my lord. The judgment starts at page 29. My lords, this person Ajay Malik is the accused. At page 36, the 1.1 offenses alleged against Ajay Malik. Analysis in this regard will address each of the offenses enumerated against Ajay Malik, namely wrongful confinement 343, human trafficking under 350, 370, and, my lords, criminal conspiracy. Now, my lords, on this trafficking business, if your lordships have paragraph 18 at page, my lord, 38. We now turn to the allegations against Ajay Malik under section 370 of the Act. I'm sorry, my lords.
Yes.
And other co-accused. However, closer examination revealed that the bulk of the FIR primarily on two neighbors, etc. In the complainant statement against 164 CRPC, allegation against seemingly diminished. See, she provides a detail of her neighbors, etc. Then we leave that. Then there is a no objection which she gives. And then, my lords, if your lordship sees, my lord, that second paragraph. In contrast, the second paragraph of 18, the only mention of Ajay Malik in her statement pertains to his alleged refusal to send her home until alternate arrangements were made and his having allegedly locked her in a room. The complaint also notes that Ajay Malik had left a mobile phone with her before leaving for Delhi and maintained regular contact with her during that time. So please note this, Miller. Employer puts the employee in a place, gives her a mobile phone, locks her from the outside. Question is, was it trafficking? Court says no. That your lordship will find. Para 20. In this vein, having duly considered all these aspects in total, we are of the opinion that no prima facie offense 370 has been made out. Not only there is no evidence of neglect or exploitation by Ajay Malik, but her own so-and-so abuse also may be given. We deem it important to note that there may have been instances suggesting some degree of labor-based exploitation of the complainant. This is not evident from the face of the record, and we are not inclined to initiate an inquiry into this. In any event, such allegations do not constitute offense of 370, and we cannot conceivably find Ajay Malik guilty of trafficking and exploits. Lord, this is a worst case where that person locked her in a room. There's no mental element, my lord, in this. And here, my lord, there was a clear, either it is harboring or, my lords, it was a clear case of harboring because he put her, but the court said, no, this is not even harboring because you gave her access and it's not done clandestinely. Because if it is done clandestinely, the mobile would have been taken away. Now, my lords, my submissions on this, if your lordships have. Lords, that lords, what? No? Okay. Anyway, just show it from. Your lordships have, my lord, page. Your lordships have page 37.
Of notes.
Of my note, my lord. Yes. Lords, I have extracted, my lord, what the section is. And then, my lords, I have explained what the, my lord, according to us, where our submission, where our, my lord,
This
submission.
already argued.
Yes, I have already argued. I just want to point out, I have put it down in writing, my lord. Then, my lords, I straight away turn to how the trial court has dealt with this in paragraph 53. I'll just read this and then I'll come to the trial court. The learned trial court in para 450 commits a grave error by holding that receiving custody or making out the offense is not necessary and the offense is complete to the ingredients of fourthly or fifthly by practicing fraud or deception or abuse of power or by inducement. Observation is completely misplaced, no evidence. Then, my lords, kindly turn to 55. Evidence on record also shows that there was no attempt made by either of the accused person to follow up or put any further pressure or in the mind of the prosecutrix or a family to ensure that they don't go anywhere else after the 10th or after the 9th when they left, or immediately reach the place where the accused Asharam was. Once the prosecutrix was taken home on the 9th, the control and the custody of her was with her parents and the element of fear or inducement was broken. Hence, there was no continuous or constant fear or pressure by the accused person, which could infer the control of the prosecutrix. That is for fifthly and sixthly. They still have to satisfy, my lord, A, B, C, D, E. It is also relevant to point out that.
Got the drift of your argument.
Yes, my lord. I'll just finish this.
As far as 370 is concerned, you say that they were set free from the group.
Yes, yes, no. Yes, that's the.
They were on their own throughout.
That's right. That's right.
It was only one-way traffic. They were trying to reach out,
that's
taking time. Whether
just how the trial
Jodhour,
court,
whether Delhi,
correct,
this,
whatever
that,
it is.
So 370
Correct.
not made out
Yes.
at all
That's right.
on all squares, whether it's A to E or
yes, no.
firstly to 6.
But just to buttress that, if your lordship sees 56
You can
also.
move on from there now.
Yeah, I'll just move on quickly.
And of course, you would argue that if 370 principal offence is not there, where is the question of 120B?
120. But 120B, my lord, also has some bearing on 376D
You
also.
would of course argue that
Yes,
even if the trial judge were to say firstly or sixthly, whatever,
Yes,
in
correct.
the absence of A and
A
B,
and B,
you can't
correct,
have bits and pieces.
Correct. No,
You
just
can't have bits and pieces of 370
That's right.
and then invoke 120.
Correct. Now, just have also 56, but I want to read the evidence. It is also relevant to point out. I have tested your lordship's patience enough. I want to hurry this up. It is also relevant to
This,
point
we are
out.
saying come to the principle.
Yes, but I just come. Kindly see this because I just want to complete.
We must honestly tell you were not in. Mr. Jain is also argued. Mr. Vineet Jain
Yes,
has
my lord.
argued.
But I am also saying, my lord, that all this is relevant.
Because in that case, the principal offence is 370 in his case.
Correct, my lord. But what I'm saying is, for me, everything is a principal offense. Everything is bogus. Everything is principal for me. I want to clear my name, my lord. Because trafficking is something for a spiritual. It's really bad, my lord. 375 is worse. but I want to get rid of it. So just that's why, my lord, I am laboring on this. 56.
Sir, you don't have to.
Yes, my lord.
What we're saying is you made your point.
Yes, I bow down, my lord. But just 2-3 things, my lord. Not sometimes, my lord, we are a little anxious that all the points should be there before the court, my lord, that we should not, as lawyers, not miss out on any point. That's
But
why.
that is why this labor you've done.
Yes, my lord. Now, para
If you miss
56.
out, then there's a problem.
Yes, sir. I just want to just point that out and leave and not argue more than 10 seconds. Not IO 40, whose PW 43 in her cross examination has admitted between 9th and 16th there is no evidence of any telephonic conversation or follow up by Shilpi with the prosecutrix. Now, my lords, paragraph 458 of the trial court is also important. Lordships may note, I will not read the trial court. The trial court categorically observes that in the case in hand, there is no direct evidence available against accused Sharad and Shilpi. They had sent the victim to accuse after that he might sexually exploit. However, oral and present on the file covers clearly physically was frightened by evil spirit. That thing has been broken, my lord, from the, if at all there is on the 9th. Then, my lords, kindly turn to 467 2 that's what has seen. Then, my lords, then I want to show, my lord, the Prakash I have shown, my lord.
ये पहले it's 450 है. मतलब मुख्य परिस्थितियों के साथ सिद्ध है कि पूर्ण रूप से स्वच्छ पीड़िता को दोनों अभ्युदगण ने भूत प्रेत का डर दिखाया, परिवार को प्रवंचित कर उत्प्रेरित किया कि भूत के इलाज के लिए अभियुक्त आसाराम से बात हो गई है, कहीं नहीं और कहीं नहीं ले जाओ, सीधे उनके पास आए. इस तथ्य से आसाराम के साथ इस षड्यंत्र में शामिल थे, इसलिए वहां भेजा.
Now, my lords, 370, one other aspect, my lord, is regarding this person Shiva. I have read, my lord, Prakash. That Prakash, my lord, 400, they tried to call. There's no phone call, not a 400, my lord. Doesn't belong to Prakash, it belongs to some Bhadoria. Right, my lord? And that trial court has categorically said that that number was not with Asaram. And your lordship asked me a question which I faltered, my lord, in my, because the evidence was too much. Lordships asked me, are the call locations of 400 available? Now, my lord, there is a little bit of story to that. According to us, my lord, it has not been proved because the nodal officer, my lord, who was brought in as PW 44, he was not the nodal officer. There was no gazette. They got somebody to prove this call locations. Now, the call locations that is discussed by the trial court while exonerating, my lords, this phone number for association to me, and says that this number, my lord, used to travel with this Bhadoria. He was in Bamer, he was in Siroi, etc. But there is no evidence to link it to me that I was using this. And court says, my lord, using the basics of criminal, that suspicion, however strong, my lord, will not replace proof. So that's why, my lord, on that 400, my lord, Prakash is out. Now, as far as Shiva is concerned, if your lordships have the trial court judgment, which paragraph? 419, which is, my lord, in the judgment compilation, it starts at 419, page 530, my lord.
Para 41.
Yes, my lord, para 419. Lord, at page 531. Lords, lordships are reading the Hindi version. Yes, Hindi version is page para 419. Yes, 419. The next paragraph, page 531. Thus, in whole, the middle of that paragraph, your lordship got it.
Para?
Lords, page 419. Lord, yesterday I think we had given that English another copy. I think
English translation.
I think that is the one.
English
Trial translation. That's the one.
Yes, sir.
Page 531.
Yes. 531.
Yes, sir.
This one.
Yes, in the middle of 10 lines from the bottom. Thus, in this whole event, the role of Shiva has been telling the address of accused Asaram upon asking by Karamveer Singh. It is notable that the call detail of record is of Shiva is not true. Therefore, this is important for 370. And also, my lord's common intention, my lord, for the purpose of 376, the call details are not true. This is not the prosecution version of Shiva himself would have phoned PW21 and explained the address which has been prepared by the IO about the calls side in conversation has not been shown. Conversation of Shiva with accused Asaram has been shown through Prakash, but as per the previous deliberation, it has not been proved that 400 remains with Prakash, which accused Asaram used to use. In such a situation, in my humble opinion, there is not even a little evidence on the case file to connect Shiva with the alleged crime. Then, my lords, ultimately, paragraph 427 is the clean chit. Therefore, it is clear from the above deliberations, prosecution has completely failed to prove this case against accused Shiva, as the accused Shiva at some time prior to 15, together with Asaram, constituted a criminal conspiracy and gang with purposes of to do exploitation of a prosecutory and provide any support in furtherance of the criminal conspiracy and common intention with the purpose of sexual assault of the prosecutory. Now, my lord, conspiracy with Shiva not there, conspiracy with Prakash not there. Only two person else who I can conspire with is Shilpi and Sharat. No link to me except through these two persons. And Justice Gawai's latest judgment, that judgment is there, my lord, that if the allegation is conspiracy and the link in the conspiracy is broken or the other co-conspirators have been acquitted, there's no question of sentencing these people for conspiracy. I'll straight away come to the conspiracy angle, my lord, now on the law, and then I'll come to 14th, my lord, on this Bhutwali Ladki. If your lordships have, since I'm doing this conspiracy. Was 120B also, my lord, on 370 has been roped in. Both for, so that's why I just want to satisfy your lordships on that. Just one or two judgments, my lord, on this, I guess, but it's law well settled, but my lord, straight away, if your lordships turn to my lords, Lords, first, serial number 28, 2012, 9 SCC, page 696 at page 272 of the compilation. At page 278.
Sorry, I missed it there.
Yes, what is the compilation?
Judgment.
Same.
No, my lord, that's another compilation.
Another compilation.
That is compilation 2, my lord. This is compilation 1.
Is that scanned?
No, my lord, we'll just scan it during. Yes.
Now.
So we'll 270. Yeah, it starts from page 272 at page 278.
Start reading in the meeting.
I'll read it, my lord. Lord, this is bringing a cold to Newcastle, my lord, but I'll just do my duty, my lord. The offense of criminal conspiracy as its foundation, where an agreement to commit an offense or to achieve a lawful object to unlawful means.
278 page.
Page 278.
Para 15.
Para 17.
15. The offense of criminal conspiracy.
The last paragraph.
Last.
I don't want to read the.
Same as the offense of criminal.
Yes, yes. Such a conspiracy would rarely be hatched in the open, if therefore direct evidence is not available. Proof or otherwise is a matter of inference. In drawing such an inference, the court must consider that the basic fact and circumstance from which an inference is to be drawn have been proved beyond all reasonable doubt, and thereafter from such proved and established circumstances, no other conclusion except that the accused had agreed to commit the offense can be drawn. May 2013 happened, not happened. What happened? Did that touching happen? Not happened. Two views. 2nd, 3rd August, my lord. Bhutwali, that Bhavya happened, not happened. Two versions, two inferences can be drawn. 7th, 8th calls were made. Your lordships have seen. calls were made. Whether calls were made, not made, two inferences. STD, the STD booth numbers, my lord. 535062, not belonging to Shilpi, not in the possession of Shilpi. Only 62. IO says, bring the 62. It is confiscated. And then the trial court links that 62 to me. No evidence otherwise. And that she was asked to bring. So two inferences possible. Going further, my lords, whether, my lord, when they met, allegedly, my lords, in Sharad's room, Sharad told her, you are possessed. Don't go here and there. Unhi ke paas leke jao. Two inferences possible. This happened. This did not happen because the entry in the register with the prosecution itself says every time you enter the school, you have to enter and you record your name. Your name is not there. Then, my lords, we go further, 10th to 14th. I have shown, my lords, they again and again say, we called Shiva. There are no calls on 11th, 12th, and even on the 14th at 2:30. Why are they doing all this? Are two inferences possible? I respectfully submit yes. Now that is, my lord, as far as this judgment is concerned. Huh? Yeah, okay. Naturally, in evaluating the proved circumstances for the purpose of drawing any inference, adverse to the
benefit of doubt must go to.
That's
the last.
Yes, sir. Then, my lords, the next judgment is the Parliament attack case. That's the lords main judgment. We all rely on criminal conspiracy, my lord. The law from England, etc., everywhere has been discussed. I'll just point out the paragraph. Lords may, my lord, consider it. But the judgment starts at page 281, and the relevant judgment, a relevant portion, my lord, at page, just one second, 369 onwards, my lord. Lord, what is conspiracy, my lord, is 92 Hari Singh Gaur, 94, I want to read it, my lord. Now, but 96, I just want to place it, my lord. That is Kehar Singh. It is, however, this is important, my lord. It is, however, essential that the offense of conspiracy requires some kind of a physical manifestation of agreement. This is important, my lord. When we were talking of 370 or 376D, trial court says no, mental element is enough. Fraud and deception. But where is the physical element? The physical element is A, B, C, D, E. There's no physical element here. The express agreement, however, need not be proved, nor it is necessary to prove the actual word of communication. The evidence as to transmission of thoughts, sharing the unlawful. Where is the transmission? Where is the evidence of transmission? There is no all the call details disproved. Then, my lords, the expression physical manifestation seems to be the phraseology used in the article.
As the judgment says, it doesn't say it has to be physical
Sorry, my lord.
transmission of thought.
Physical, that's what it says, my lord. The evidence.
Transmission of
Yes.
sharing the unlawful.
Before that, my lord. Before that, physical manifestation is also there, my lord. It is, however, essential that the offence requires some physical manifestation of agreement. Physical manifestation. Then, my lord, the expression physical seems to be the phraseology used in the article referred to in so and so. However, the said act shall not be the overt act, which is a different concept. As rightly said by the learned singer, the phrase refers to manifestation of the agreement, such as by way of meetings and communication. There has to be something, my lord. Then, my lord, I don't want to, this is, my lord, very illustrative. But 97, if your lordship sees between placetum E and F, the circumstances so prove.
It says overt act is not required.
Yes, but kindly see further. The circumstances so proved must form a chain of events. That is para 97, placetum E and F. The circumstances so proved must form a chain of events from which the only irresistible conclusion that the guilt of accused can be safely drawn and no other hypothesis against the guilt is possible. That's the standard, my lord. And then 90, Mela, I'm not going to labor again and again, but just, Mela, lordships may not read it. A few bits here and a few bits there, on which the prosecution relies, cannot be adequate for connect. So This is a few bits here and few bits there case, my lord. Para 99, the present case of the prosecution, if I can put it, my lord, in the words of the Supreme Court, is a few bits here and a few bits there. And there ends the prosecution story to convict. Huh? Yeah. And my lords, this is on the conspiracy. Though what happens, my lord, in a conspiracy when the co-conspirator is acquitted? That, my lord, is 2013 7 SCC page 45, page 480, relevant portion at page 489.
You are saying that once they have been acquitted,
Yes, my lord.
chain is broken.
Correct, correct.
So you can't do few bits here, few bits there.
To
That's the
connect
para
me
99.
again.
You can't do cherry picking.
Correct, my lord. Correct.
So now chain is broken.
Correct.
Once this is broken, you treat it as broken.
Correct. That's all, my lord. I just give the paragraph number. Paragraph, my lord, you can make a note. In this serial number 30, my lord, it is paragraph
You
number.
can't create a metaphoric link.
Correct, I board on.
It has to be physical link.
Yes, my lord. There has to be somebody. If I have to conspire, I alone can't conspire with myself. There has to be a co-conspirator.
And the transmission of thoughts cannot be spiritual.
Yes, my lord.
It has to be physical. That's
Correct,
what
my lord. For the entire, whatever little I have learned of spiritual life, my lord, Guru transmits, my lord, his thoughts spiritually. That's the whole purpose of our Hindu, my lord, a Guru-Shishya relationship. My lord, you are aware, Dakshinamurti never spoke. There's only a spiritual transmission. But, my lords, when we are talking about IPC, there has to be a physical manifestation of that. Now, my lords, anyway, my lords, kindly see
if
just.
prosecution adopts that, then they'll say case is proved. Guru has used his spiritual power.
Yes, my lord, that seems to be that case.
Communicate.
Correct, my lord. That seems to be their case.
And that is
Yes, ma'am.
not overt,
Alright.
it's a covert act.
Correct, my lord. That seems to be their case, but it can't, my lord, stand in a court of law. Now, my lords, kindly turn to paragraph page 489. I just
Giving it back now, what is this?
no, this the last point on this one. That the co-conspirators are. I'll just para 29 may be flagged, my lord. That's all.
29 of it plus. Indeed, what is
We will be failing in our duty. If we do not note another submission of the learned counsel for the appellant. It is urged by him that A2 stood on the same footing as the appellant. The High Court should have acquitted him. Then, my lords, it is also canvassed by him that A2 has been acquitted of the charge of criminal conspiracy. Therefore, the appellant deserves to be acquitted. The High Court has taken note of the fact that A2 was not identified. Now, then, my lord, the court says, as far as conspiracy is concerned, under 120B, we are inclined to think that the High Court erred. Sorry. Yes, my lord. In not recording any order of acquittal under one, as no other accused had been found guilty, the conviction under 120B cannot be sustained when the other accused person have been acquitted. That, my lord, is an old judgment, relies upon which we just gave. They rely upon, my lord, the judgment of Fakhruddin. My lord, where, my lord, the first point, paragraph 5 of that, the second compilation, my lord. Where I read that. Yes. Lord, one.
saying that 120B essential ingredient is
Yes, my lord.
communication,
Correct, my lord.
meeting of mind
Yes, my lord.
through a chain,
Yes.
because conspiracy means number of people involved.
Yes, my lord.
Through a chain, if the chain is broken,
Yes.
then the charge goes.
And the second point is, if
Chain
the
is broken, therefore that reflects there is no meeting of mind.
and the second sequitur to this is, if the others co-conspirator allegedly have been acquitted, then, my lords, this person can't be roped in for one time.
It's break.
Correct.
Acquittal means break.
Correct, my lord.
If
Now, my
they are
lords.
not acquitted, you won't be arguing this.
Yes, my lord. My lords, there are two other judgments just to finish the latest. These are, I've cited old judgments. I want to cite the latest one on this, my lord, of Justice Gawai, and then I'll end with this. Just give that.
Hello.
Page 126.
Yes.
My lords, this is, my lord, Justice Reddy and Rishikesh Roy, paragraph 12 at page 128. It is fairly well settled to prove charge of conspiracy within the ambit of 120B. It's necessary to establish there was agreement between the parties for doing an unlawful act At the same time, it is difficult to prove established consider direct evidence, but at the same time, in the absence of any evidence to show meeting of minds between the conspirators for the intended object of committing illegal, it's not safe to hold a person guilty for the offense. A few bits here, a few bits there, on which the prosecution of crime of criminal conspiracy, even the alleged so and so. So the same thing, not few bits here as Navjot Sandhu said, and the last judgment on this, my lord, is Justice Gawai, which is, my lord, the next judgment starts at page 131 and relevant, my lord, at page 138. My lord, principle, para 27 and 28. Principal ingredient of the offense of under section 1 is an agreement. Such an agreement must be proved to direct 27 and 28 minutes. Page 138 minutes. Sorry. The court has to necessarily ascertain whether there was an agreement. In decision of Sugatan, this court noted that an agreement forms the core of offense of criminal. Then not these bits and pieces, my lord's jurisprudence is put in. Cannot be held adequate. The most important ingredient for the offense. Now the italicized the last, my lord, placitum H. For the offense of conspiracy, some kind of physical manifestation is required. Express agreement need not be proved. Evidence of transmission of thought, sharing the unlawful act is not sufficient. Well, that is on 120B. And when we are on this compilation, my lord, the lordships have seen initially in May 2013, 3 people, students who are alleged to be there, they are not examined. Then Bhavya not examined. Then, my lords, the Sims are in the name of somebody else. Those persons are not examined. Why? And what is the effect of that? I just want to, my lord, if your lordships just see. If your lordships sees, my lord, the judgment of Gaurav Maini, which is 2024, starts at page, my lords, 343. My lord, Justice Mehta's erudite opinion, my lord, on how, my lord, the court should have appreciated. Please have a look at, my lord's paragraph 49. Page 362. When Bhavya says, my lord, that she was there, she's being coerced, she writes letters, etc., what should the court have done? Can it just be ignored, as the trial court has done here? That is page 362. A conjoint reading of section 311 and section 165 of the Evidence Act makes it clear the trial court is under an obligation not to act as a mere spectator and should proactively participate in trial proceedings so as to ensure that neither any extraneous material is permitted to be brought on record nor any relevant fact is left out. But I dare say, my lord, in this case, there can't be two opinions that Bhavya was a relevant fact. After, my lords, she could have been summoned and then her evidence could have been disregarded. But not summoning, my lord, is, according to me, fatal. It is due. 3 students also. Yes, yes. It is the duty of the trial court to ensure that all such evidence, which is essential for just decision of the case, is brought on record. May 2000, 3 students. These, my lord, whose names are there, those Sims, Manju, etc. Have you given it to Shilpi? Yes. Then similarly, my lord, para 51. We are fully satisfied. The trial court failed to perform its lawful obligation under 311, read with 165, as the most vital witness whose deposition was imperative at arriving at the truth of the matter was not produced by the prosecution, and the trial court took no steps whatsoever to summon him. Then, my lords, the principles which ultimately the court culls out, 364, my lord. I said adverse inference has to be drawn I said that I'll show the judgment. This is the line in the judgment, paragraph 53.7. The prosecution failed to examine the most relevant witness Shamlar girl, which compels the court to draw an adverse inference against the prosecution. Now, my lords, we come to what has happened on the 14th. Lordships have seen, my lord, the weight required for the purpose of proving conspiracy. And till now, my lords, there's no conspiracy, according to us. Your lordships kept on asking me, my lord, rightly so, what must have been the motive? Why are they trying to frame you? That I will come to, my lord, on 3-7, but I just want to indicate broadly, my lord. There was a professor. I'll show that and make that good by material, but today may not be required. But I just want to indicate, since the question had fallen from the court, I just want to give it a 2-minute answer. There was one, was a teacher, my lord, the school where this girl was studying. He was sacked in about April 2013. After the sacking, my lord, prosecutrix to her mother, but I'm not trying to shame here anybody, my lord, but since I have been put in a corner, I have to say all this. It's very uncomfortable for me. It's one thing to, my lord, wanting to clear your name, but I am not the one who wants to besmirch anybody. But since, my lord, I have to do this unpleasant task, your lordship will kindly pardon me. This person, this prosecutrix mother, my lord, has a phone. Has a phone, my lord. That number and all are well, my lord, documented as that. When the prosecutrix is on vacation, and in the year 2013, there are 445 messages to this person. Nothing turns on it, my lord, at first blush. She can have, my lord, conversation with a retired professor, no doubt. No problem. All, my lords, in that time frame when she's at home. Then, my lords, comes the fatal night of 15th for me. They say it's fatal night for them, but it's fatal night for me because my entire career has been finished. On the fatal night of 15th, incident happens between 10 and 11. And then the messaging starts with Pankaj Dubey after the alleged incident. Now, my lords, was it not the duty of the prosecution to bring those material on record? Because that would show what the prosecutrix was thinking just after the alleged incident. According to us, the incident didn't happen. Was she told at 11:30, 12 o'clock, frame him? And why this assumes importance is that, my lord, the prosecution does not file the call details, despite an order of this honorable court of Justice Sandeep Mehta, which said, don't filter the call records. Please present all the call records between the prosecutrix family, whoever, my lord, that phone was, and the accused. And as we come to, my lords, the investigation, I will show selective, my lord, phone calls, or the call records have been summoned only of the accused. Why? Because this was the, according to me, my lord, if your lordships were to ask me, my lords, Human beings, ocular evidence, people may lie, may not, but not circumstances. If immediately after the incident, alleged incident, according to me, incident didn't happen. She never went to the kutia. But at 11 o'clock, 12 o'clock, goes up to till 12:05 early morning or late midnight. Somebody is messaging using the mother's number and certain messages are sent. Is it not relevant? What were the messages? According to us,
What is it? Proof that this will happen.
yes, my lord, the messages are it shows the call details. What happened, my lord? This person got arrested in another case because, my lord, the allegation, Dubey, allegation against him was that, my lord, he was planting some skeletons in A1's ashram in Kashmir. He was arrested there, and the police recovered his phone. And in that recovered phone, my lord, these messages are there on the date of the incident to this girl. I don't want to say anything more.
Prior to this.
No, on the date of the incident, on the night, just after the alleged incident. According to us, incident didn't happen. I just asked myself, my lord. Anyway, my lord, let's leave. Lord, I'll show that, my lord. I'll show that. That's on the CDR. But, my lord, I'll feel that because that was
Is it part of the?
yes, my lord, it is part of that. That is on the 15th. I'll come to it when on the 15th. But since your lordship asked me that question, I was duty bound to answer. Now let's come to, my lords, the 14th story. Justice Mehta's judgment, my lord. We'll give it at the appropriate. I'll just read it. I just read it, my lord. Yes. However, it is made clear that if the prosecution desires to file the call details in addition to the certificate of nodal officer, entire call details of the relevant without any filtering shall be produced from the call. Anyway, my lords, now my lords, as far as motive is concerned from the defense side, I don't have to prove motive beyond reasonable doubt. I am only saying that whether the evidence as presented by the prosecution can be credible or there is some other angle to this. That's all I have to show. I just have to create that doubt. That's all. But the trial court seems to suggest I have to prove the motive. That's against all canons of criminal to force the burden on me. But anyway, my lord, I'll come to that. But please have a look at, my lord, how I want to start this. Now, my lord, still May 2014, I have shown, my lord, there can't be any conspiracy. Faced with this, how does the prosecution pin the conspiracy on me? Trial court says when they met in a public gathering on 14th evening, a lot of people were sitting. And in that setting, my lord, A1 looked at this person, prosecutrix, and say, "Oh, you are the Bhutwali lady." And what is it? It is indicating that you knew who she was. That's the case which has been set up. If your lordships were to carefully see the statements, it is clear, my lord, that father told in the satsang that my child has a problem. Problem was explained. And on being explained, the girl stood up. And when the girl stood up, A1 said, "Oh, you are the girl." how can that be the evidence of conspiracy? I won't straight away come to the statement now. What big is? Record page 46. Now, my lord, on the 14th incident. Yeah. Because after they went inside the gate and all that, not gate was opened by Shiva, which is formed to be false in the evening. Which that is, let's see the first one of the handwritten complaint. कुछ देर बाद उन्होंने पूछा तुम कहाँ से आए हो? मैंने बताया कि मैं गुरुकुल से पढ़ती हूँ। तो उन्होंने कहा वो मेरे भूत निकालो। कंप्लेंट एनजीओ रिपोर्ट मणि में 14 की रात बापूजी ने प्रवचन के दौरान स्वयं को उसके माता पिता से मुलाकात की। 164। फिर उन्होंने मुझसे पूछा कहाँ से आए? तो मैंने बताया कि छिंदवाड़ा से। तो उन्होंने कहा कि आ जाओ, कुछ निकालते हैं इस्तेमाल। फिर बापू ने 161 बापू ने पापा से पूछा कि कहाँ से आए हो? तो पापा ने अपने और मेरे बारे में काइंडली नोट दिस मिनट दिस इज अ कंप्लीट इंप्रूवमेंट बट 161। फिर बापू ने पापा से पूछा कि कहाँ से आए हो? तो पापा ने अपने और मेरे बारे में रॉन्ग स्टेट। तो बापू ने कहा कि अच्छा तुम भूत वाली लड़की हो, आओ तुम्हारा भूत उतार। तो my lord, whether the complaint version is true or 161 is true, with credible on this, can you pin me down? Then my lord, kindly see PW5 evidence. बापू ने हमसे पूछा कहाँ से आए हो? तो मैंने कहा कि छिंदवाड़ा गुरुकुल से आई हूँ। तो बापू ने कहा कि छिंदवाड़ा गुरुकुल आपके नृत्य परीक्षण का भाग। तो मैंने कहा कि छिंदवाड़ा गुरुकुल से आई हूँ। तो बापू ने कहा कि अच्छा छिंदवाड़ा गुरुकुल की भूत वाली लड़की है, आओ तुम्हारा भूत निकालते हैं। इसमें बापू द्वारा आपको पूछना और आपके द्वारा बापू को बताना 161 के बयानों में कॉन्ट्रडिक्टरी। यह सही है कि प्रदर्श पुलिस बयान है बापू द्वारा पापा से पूछना और पापा द्वारा अपने और मेरे बारे में बताना लिखा है। बापू द्वारा मेरे से पूछना और मैंने द्वारा बताना अंकित नहीं है। आज कुछ कहा कि लिखा है बापू ने कहा कि वो अच्छा तुम भूत वाली लड़की हो। अगेन my lord, clearly. Now my lord, kindly see father. This my lord really goes. फिर हमसे बातचीत की। सत्संग में बैठे लोगों से मेरी गुरु भक्ति और श्रद्धा की तारीफ की। जब हमने हमारी बेटी की समस्या बताई, इम्पोर्टेंट है, जब हमने हमारी बेटी की समस्या बताई तो उन्होंने कहा कि हम अभी भूत उतारते हैं। Then my lords chief, आशाराम ने मेरी बेटी से पूछा कहाँ से आए हो? उस समय मैं भी खड़ा हो गया। पहले मेरी बेटी खड़ी हुई। मैंने खड़े होकर मेरे बेटी की प्रॉब्लम बताई तो मेरे बेटी ने बताया कि छिंदवाड़ा गुरुकुल से आई हूँ। वहां पर बापू ने कहा कि अच्छा भूत वाली लड़की हो, आओ अभी भूत निकालते हैं, भूत उतारता है। फ्रॉड मेरे मुख्य परीक्षा के पेज नंबर 3 पर लिखा है कि बात वहां पर बापू ने कहा हाँ अच्छा भूत वाली लड़की। यह भूत बात मैंने पुलिस वालों को बता दी, लेकिन उस बात मेरी पुलिस बयान में क्यों नहीं लिखी मैं नहीं बता सकता। मेरे मुख्य परीक्षा के पेज नंबर 3 पर लिखी यह बात असाराम ने मेरी बेटी से पूछा कि कहाँ से आए हो। उस समय मैं भी खड़ा हुआ हो गया। पहले मेरी बेटी खड़ी हुई। यह बात मैंने पुलिस वाले बयान में बता दी थी। पुलिस वाले ने प्रदर्शन टीवी दो में बयान क्यों नहीं लिखा। As we go forward, I will show, my lord, the very, apart from the fact that this Bhoot wali ladki is completely demolished by the prosecution's own witness. If you see this, he says, come, I will exorcise your ghosts now. And he tells them an upay. He says, aap Ahmedabad jao. And maybe tomorrow, whenever you're not. That will take some time. No? He says, you go to Ahmedabad and do Anushthan there. That's on the 14th. But what happens, my lord? They stay back on the 15th against his advice. Why? We don't know. So therefore, my lord, till now, my lord, in my respectful submission, the entire case of the prosecution seems to be some giant, my lord, plan. To fail me.
मार्च में इसलिए नहीं दिखा। अच्छा ये कोई लोकल हॉलीडे है? लोकल है? लोकल हॉलीडे नहीं।
18, 19, sir.
हाँ लोकल हॉलीडे है।
What's your lordship kind permission, my lord? Can it be on the 18th and 19th, sir? Well, I have some difficulty. Yes, sir. But that week we would court, Supreme Court is just opening, sir. 18, if it's possible, my lord, 18, 19. 12th, 13th, my lord. Monday, Friday, a little bit difficult. Nowadays in Supreme Court, they are having miscellaneous for the 17th also. The 18th night, subject to your lordship's pleasure, my lord. Otherwise, my lord, on the 12th, my lord, 12th. 12th, one day I'll do, my lord, then maybe. 13th. I'll do full day on the 12th. 18, 19. Well, I'll leave it to, I don't want to push beyond the point, my lord, either. 12. I'll make a request on the 12th.
permission for one matter, my lord, of the single bench of lordship, my lord, for extension of bail by. वो कल परमिशन ली थी my lord, वो कल के लिए अगर रिक्वेस्ट थी
अब
मैम,
लगवा दो, यदि कल नहीं रहती दीदी
कल के अब रिक्वेस्ट
Not
दिक्कत तो एक्सटेंशन का तो लग जाएगी, वैसे भी चैम्बर लग जाएगी, नहीं चैम्बर हो जाए।
Or the court master can just complete the record. 1 to 12 may not be earlier part, so that's close, my lord.
Take it as a clue from me.
No, my lord, I just wanted to complete. Anyway, we wanted to give it. Just we wanted to give it anyway. So this is just the outline of the argument. That the
इधर देखो,
lordship's notes are complete. I don't want. Grateful.
सर एक एप्लीकेशन
सीरियल नंबर 10 में क्या हुआ? सीरियल नंबर 10 में क्या हुआ?